Hello and welcome to my show, The Legal Messages. In today's episode, I shall be discussing one very important aspect of Indian Evidence Act, that is burden of proof, which is described in section 101, 102 and following sections. If I will describe it in terms of the Bare Act, the language of the Bare Act, it will be a little bit not convenient, or should I say not very lucid to understand. So what I will do is that I'll do 2-3 things simultaneously. One, I'll take the Bare Act. Second, I will be giving some examples, illustrations, and third, in between, I shall try and put in some cases. So hope that at the end of some 7, 8 or 10 minutes of this video, you would be in a better position to understand what the burden of proof is, what does the Act talks about regarding the burden of proof, and what are the different cases and the finer points of it. Now, in terms of the Bare Act, the Bare Act says if a person desires from a court that the court should give a judgment regarding what? Judgment regarding the liabilities or rights or liabilities regarding the existence of a certain fact. The person will have to bring in the proofs for the establishment of that fact. Means there are 3-4 components. One, the person expects from the court to give a judgment. Judgment on what? Judgment regarding rights and liabilities. And on what? Rights and liabilities on what? Rights and liabilities on certain facts. Existence of a certain facts. For example, if a person say that he is the legal heir of some person, say X, so and he wants court to give direction regarding that so that he can get some properties in terms of inheritance. So he wants the court to give judgment in his favor regarding his rights. So he will have to produce facts, produce proof, so that the court could give judgment. So who will have to produce the evidences, the documents? It will be the person who wants the court to give judgment in his favor. So here, as the person is required to give document, witness, evidences to get the judgment, it is said that the burden of proof to get the judgment lies upon that person. Now, let us understand it through an illustration. There is a person A who institutes a case against X, accusing him that he attempted to kill his friend Y. Now, in order to get the judgment from the court, what is required? He will have to bring in witnesses, evidences, documents in support of his charges, in support of his accusation that it is person X who has attempted to kill Y. Now, since X has accused, or rather A has accused X of attempting to kill his friend Y, the X will come up. X will defend itself against the accusation. What will X be required to do? Will he be required to counter every evidence, every witness, every point that A has produced? No, that is not required. A will just bring in some evidence so as to create doubt in the mind of the court, so that the court does not get to the point of beyond reasonable doubt. In order to convict a person, an accused, the court needs to get to a point where it feels that it has arrived to a point of beyond the reasonable doubt. So what X will do is that try to create some doubts in the mind of the court, and in this way he can get the acquittal. Let us understand it by an example. In the very famous Arushi Hemraj case, the Talwar couple was convicted by the CBI court, and later on the High Court acquitted both of them. They were convicted on the basis of circumstantial evidences, and there were no direct evidence. What did the Talwar couple do in the court? or what did the lawyer on behalf of Talwar Kapoor did? They created some kind of reasonable doubt in the mind of the court and got the acquittal. So here we see that the accused can get acquittal by creating a kind of reasonable doubt in the mind of the court. Now come back to the language of the Bail Act or the contents of the Bail Act. As per the explanations of the Bail Act, the burden of proof has two elements. One, to establish the case, and second, to adduce the evidence. The first point, to establish the case, is dealt in section 101 of the Indian Evidence Act. The responsibility of establishing the case lies with the person who wants the judgment in his favor from the court. That I dealt so far. Now, section 102 talks about adducing of evidence. Means bringing out evidence. Again, let's come back to the example that through which I was trying to explain. As A has accused X of attempting to kill his friend Y, X comes up with an argument that on that particular day in which there is accusation of him attempting to kill Y, he was not present in that city. And he says that on that day, suppose he was not in Rajgir, rather he was in, say, Kolkata. Now, the onus to prove that the accused was in Rajgir on that day goes back to the person who has accused him, that is A. Now, A will have to bring in evidence, facts, documents to prove that X was there in Rajgir on that particular day. And now X comes up with, say, some witness who says that he has seen, rather A comes up with some witness who says that he has seen X on that particular day, and A also comes up with, say, CCTV footage which shows X to be present on that particular day. Now again the onus shifts. Onus now goes to X to prove that what A has brought in against him is not correct. Now X says that the CCTV footage that A has brought is doctored. X claims this, and he also says that the witness is lying and he was not present on the day of the alleged occurrence. What he does is that he shows some receipts of his stay at Kolkata on that particular day, and he also shows the ticket on which he went to Kolkata. Now again the onus shifts to the person A who has accused X of attempting to kill Y. So what we are seeing in this example is that onus is shifting from A to X, back to A, back to X, and one to one. So what we see is that the onus shifts, but the burden of proof remains fixed. The burden of proof remains with A to prove that it is X who is responsible, who has attempted to kill Y. The High Court of Gujarat, in a case RanchhodBhai Vs Babu Bhai of year 1982, has said that the burden of proof remains fixed and the onus shifts from one party to other, and the burden of proof lies on the person who has to prove the fact. Section 102 also says, that the burden of proof lies on the person who would fail if the person does not bring evidence in his favor. Here, A is trying to prove the fact that it is X who has attempted to kill Y. If he does not bring evidences, he will fail. Thus, the burden of proof lies on whom? The burden of proof lies on A. There have been cases, some important cases regarding different aspects of burden of proof. One case is between Dina versus Union of India of 1983. It is a Supreme Court case. This case is different in a way that it has talked about some crimes regarding banking and all. In this case, the Supreme Court says that burden of proof is not required in the cases where we find direct evidences, like we find direct record, like the photocopy of the passbook or the statement regarding the transaction and all. So if a person claims that he has been duped or some crime has happened against him, some offense has happened against him, and some money has been taken from his account. So in order to prove that the money has been taken, he brings out the transaction statement of the transaction. It will be sufficient. In another case, it is between Gaurishanker versus Union of India of 1994. This case is regarding any act. If a person accuses an act or says that an act is in contravention to the Constitution of India, the court says that it is the responsibility of the person who says that the act is against the provisions of the Constitution to prove that the act is against the provision of the Constitution. And so long as he is not able to prove, it will be held by the court that the act does not contravene the Constitution. So overall, we have seen in this video that the burden of proof lies on the person who wants the court to give judgment in his favor regarding rights and liabilities. And he will have to bring the evidence in support of the fact he wants to establish. Hope you understood it in a good way. Thank you very much.